Good morning, everyone. We've started a whole series of information sessions on wills around testate succession and the challenges that women in particularly face during this period. Last week, we had a whole session, a webinar, where we discussed various challenges from custody to religious to challenges which women face upon the death of their spouses. Today, we have the Department of Justice. We particularly have the Master's Office, where we have Ms. Penelope Roberts, and who holds a BProc degree from the University of the North, and she joined the Department
Morning.
of Justice in 2004, where she started as an estate controller. Now, Penny has been with the department for many, many years, and she's always been very passionate about education around, you know, ensuring that people on the ground understand the why the master's office is there and how they can assist. But also in 2008, Ms. Roberts, I would say, she moved to the department's regional office in the Western Cape, where I met her. And where she worked as a legal admin officer, and she was dealing with, amongst others, maintenance issues, domestic violence, equality court, small claims court. And then in 2012, Ms. Roberts then relocated to Johannesburg. Quite a sad loss for the Western Cape, but she joined the office of the Master of the South Gauteng High Court as an assistant master. And in August 2013, Ms. Roberts was promoted to deputy master at the office of the Master of the High Court. So on the 1st of November, Ms. Roberts also, she was appointed as the master for the office of the Gauteng High Court. And I just want to say congratulations, Penny. I never had that opportunity to actually say, but you have come a long way in the department. And I know we have done so many imbizos together. And I know that today is going to be a wonderful session, and we are really going to learn from it. So I'm going to hand over to you. What I'll do is that I'll put my video off, and then we'll hand over to you in terms of your PowerPoint presentation. Thanks.
Okay. Thank you, Shiam, for the wonderful introduction. It's very much appreciated. Yes, we work together in the Western Cape. Can you believe? Yes. So today I'm going to do my presentation based on testate succession and the different types of wills. So I have been doing a lot of community outreach programs, and whenever we go out teaching members of the public on the importance of having a will, we get so many responses, when we ask them why don't they make wills, and then most of the time they will tell us that it's expensive to draft a will, and others will just say no, they keep on postponing, and the others will just say because of the complications and all that, so they don't know how to go about drafting a will. And they would also tell us that they don't want to talk about wills because they don't want to talk about death per se. So those are the things that we encounter as the Master of the High Court. And also, before I get to my presentation, I would also like to reiterate what the Master of the High Court does, because there's a misnomer. People think that because we are the Master of the High Court, we are in charge of the High Courts. It's not so. In terms of the Administration of Estates Act, whenever there is an office of the Master of the High Court, there must be a Master's office, because the decisions that the Master takes will be reviewed by the High Court in the jurisdiction where the Master's office is situated. So basically, we supervise the administration of deceased estates, amongst other things. We supervise the administration of insolvent estates. Here I'm talking about companies which are in liquidation, or personal estates which have been sequestrated. We register inter vivos trusts. we administer the Guardians Fund, and we also supervise the administration of curatorship estates on behalf of persons who are unable to handle or manage their own affairs in terms of the law. So I'm going to go to my presentation, and then in terms of the overview, we will concentrate on what is a will, why should a person make a will, who can make a will, aspects to be considered before drafting a will, formalities where testator or testatrix personally signs a will, formalities where the testator or testatrix signs a will by means of a mark or requests someone else to sign the will on his or her behalf, requirements for the amendment of a will, what happens if a will does not comply with all of the above formalities, the effect of divorce or annulment of marriage on a will, safekeeping of wills, very important, registration of a will on the death of the testator or testatrix, and just for information purposes, estate administration costs as part of estate planning, because when you draft a will, you must also keep those in mind. So I'm going to go to the third slide on my presentation on what is a will. A will is also known as a testament. It's a document in terms of which a person sets out what happens to their estate when they die. So when I speak about an estate, basically I talk about all the assets and the liabilities which a person owned before they die. You know, people think that when you die, even your liabilities also die with you. It's not true, because creditors can also lodge claims against the estate to recover what is due to them. So when I talk about an administration of an estate, I talk about a process whereby an executor, which is appointed by the Master of the High Court, takes control of the assets of the deceased, pays the debts, and whatever remains transfers it to the beneficiaries or nominated heirs who are entitled to inherit in terms of a will or in terms of intestate succession in the absence of the will. So in a will, a person can also nominate the person or persons known as executors, as I have explained, who should administer their estate on their death. So you can nominate one or two or three, it's up to you, but basically it must be people who are actually quite au fait about the law. They would know exactly what they are supposed to be doing. And if it's more than two persons, they must be, in the same position, understanding what the intention of the deceased is with regards to the particular estate. And then the person who makes a will is called a testator if it's male, and if it's female, we call the person a testatrix. So what is a will? Continued in my fourth slide. A person's estate consists of all their assets, as I said, belongings or property, and liabilities, which are debts, which they had as at the date of death. To administer an estate means to collect or take control of all the assets of the deceased, to pay the debts which the deceased left at the date of death, and then pay the balance left for distribution to the rightful heirs of the deceased as determined in terms of the will. So if you do not have a will, the residue of the estate will be determined in terms of Interstate Succession Act. This is the act that determines, if you don't make a will, it makes a decision on your behalf as to who will inherit from your estate. So it's freedom of testation. If you want your assets to go to particular persons whom you love very much, you must make a will. So every person can make his or her own separate will, whether married or unmarried, in which he or she disposes of his or her own separate assets, or in the case of someone married in community of property, disposes of his or her half share of the joint estate. It's very important, because if the marriage is in community of property, you can only bequeath the 50% share of what is due to you in terms of the marriage. So yes, you can draft a will on your own, a separate will, or when it's possible for two or more persons, for example, spouses who are married, to make a joint will. So we are differentiating between different types of will. So it's a separate will, a single will, or a joint will in which spouses will dispose of their separate estates. Now, it's important when you are married in community of property that you should also talk about this, because the 50% share will also have an impact on the estate. What do I mean by this? There was I'll make an example. There was an estate whereby the deceased, who was married in community of property to his wife, died, and the wife didn't know that the deceased made out a will, and in that will he bequeathed 50% of his share to his sister. So now the estate had to be divided between the wife, because the wife is entitled to 50% based on the marriage in community of property, and in terms of the will, the 50% goes to the sister. So there was an infighting between the sister and the wife, and imagine the shock that took place. So, it's better when people talk about these things, so that, you eliminate the element of surprise. You don't want to be caught up in a situation like that. So let's encourage open communication so that we are clear. When a person dies, at least know what their intention was. Okay, so a will can be straightforward, a straightforward document in which the testator merely names the person who must administer his or her estate and sets out who must inherit his or her property when he or she dies. It can be a very complicated document, sometimes when it includes situations like usufructs, fideicommissums, for example, trust and other conditions. And here it would be advisable that an expert legal advice be sought. When we talk about an usufruct, it's a limited right, for example, whereby for example, the testator will bequeath the property on behalf of A, subject to the fact that B will enjoy the using the property. And then in terms of fideicommissum as well, it's also a limited right. For example, it applies in terms of immovable property, such as a farm, whereby the testator will say, I leave my farm to A. After 10 years, the farm must go to B, and then after 10 years, it must go to C. So those are the kinds of things that can make the will to be technical. So hence, you must get expert legal advice in that regard, because each situation is different for each and every person. So you can also create a trust in your will. Basically, we would call it a testamentary trust, where you also nominate who your trustees will be, who will administer the trust. So a trust is an instrument whereby the testator will give or empower the trustees to administer trust assets on behalf of beneficiaries, whether they are capital or income beneficiaries. So yes, you can create a trust. For example, if you have minor children or people your heirs are, they have special needs, just to protect them, basically. So if a will is straightforward, there's nothing that prevents the testator or testatrix from compiling his or her own will, provided that it complies with the requirements of the Wills Act. We'll get to the formalities so that you know exactly what the will must contain in terms of the Wills Act. So there are fill-in wills that can be purchased. I know CNA also sells them. However, wills can be slightly complicated, and it's preferably, suggested that you should seek expert legal advice in drafting your will, so that, because remember, it's freedom of testation, and when you are no longer there, so your will must speak for you when you are no longer there. So you must make sure that you make sure that it's valid, so that it can be executed accordingly. So once a will has been made, it can be revoked, withdrawn, or cancelled, or amended by the person who made it at any time before the death of such persons. We know for a fact that circumstances change. You would have your will drawn up. For example, if you are not married and then you get married and then you don't have children, now you have children. So each and every circumstances, it is suggested that you amend your will, regarding that, so that at least those who you want to inherit from your estate will be left in a protective situation. So the benefits of having a will are primarily twofold. So first of all, by making a will, the person who does so exercises his or her right to decide who should inherit his or her property when he or she dies. And then should a person fail to leave a will, then his or her property, after all estate debts have been paid, will be awarded to his or her heirs as determined by an act of parliament, namely the Interstate Succession Act. So basically, the Master of the High Court will determine, if you didn't make a will ask whether the deceased was married, and if they were married, what type of marriage regime did they enter into? Was it in terms of marriage in community of property or out of community of property, with or without the accrual? Was it in terms of customary marriage? Was it in terms of religious rights, for example, Hindu or Muslim rights, or whether the parties were separated? Remember, separation doesn't mean that the parties were divorced. The marriage is still in subsistence. So the parties, the separated or estranged spouse has a right to inherit in terms of the estate. So we have to exhaust the part of the marriage. If the deceased was not married, we will ask whether the deceased is survived by children. And here we talk about biological children of the deceased as well as adoptive children. And Interstate Succession Act also goes far to say that if those children have passed on, they are to step in the shoes of the deceased as well, because everyone wants to inherit. So they would even lie under oath when they report the estate to the master to say that there are no other children. Meanwhile, there are other children. So you see, it's very important that you must have a will in place. So in the absence of children, or if we know that we have children, we stop there. But in the absence of children, then we go further in terms of Interstate Succession Act to find out if the deceased is survived by any parents. If it's both parents, both Interstate Succession Act. And if it's only one parent that survives, will also ask if there are any siblings, because the parents together with the siblings will then share the entire estate. So do you then realize that we have to dig in deeper to go to all those steps in the absence of the will to find out who actually has a right to inherit in terms of the law. So a person's estate, interstate heirs are usually his or her next of kin members of the relatives. So such as are not necessarily the people whom the deceased would have wanted to inherit his or her assets when they die. So that's the benefit of making a will, because you decide exactly who you want to inherit from your estate. So I'm just going to also highlight the historical factors that women had to go through. In the past, actually, women were not entitled to inherit from estates, referring to the Black Administration Act, which has since been repealed. And it was only males actually who were supposed to inherit. So in the past, many Black persons didn't make their estate on their death. Generally speaking, Black women could not own property, and in most Black cultures, it was the eldest male child of the deceased, and then failing which his father or eldest brother would inherit the estate, and women and children were not entitled to inherit. And the case law that comes into mind is the Constitutional Court decision of Bay and others versus the Magistrates Court in Khayelitsha, whereby Mrs. Bay was married to Mr. Bay. Mr. Bay died, and Mrs. Bay went to Khayelitsha Magistrates Court in terms of the Black Administration Act to report the deceased estate. However, the magistrate informed Mrs. Bay that the law required that in this case, be appointed to administer the estate. Mrs. Bay then took the matter to the Constitutional Court. You must also understand that it was, through our democratic, it was still during our democratic, administration, and she won the case, and the case was turned. Actually, she fought a war for women, so that all women can now inherit from the deceased estate, including children. So the other benefit of making a will is that a person who does so stipulates who should be appointed to administer the estate. Here we're talking about a person called an executor. Should a person die without leaving a valid will, the executor, then the Master of the High Court, after discussions with the heirs and next of kin members of the deceased, will appoint a suitable person to administer the estate. So it's very important to say in your will that you nominate so-and-so to administer your estate, failing which so-and-so, so that at least you create an option, so that if the executor dies before you, at least there will be somebody else that will actually administer your estate. So who can make a will? Any person over the age of 16 years of age can make a will, provided that he or she is not mentally ill and they are also capable of understanding the consequences of their action. So people think that in order to make a will, you must be rich, you must be older and all that. But then, as long as we have assets, whether it's a house, whether it's a car, furniture, personal effects, money in the bank, those are assets, and it's imperative that at least you protect those, so that there can be people that can inherit from that. So aspects to be considered before drafting a will. In terms of the Wills Act, the Wills Act actually prescribes certain formalities in order for the will to be valid. So if a document which is intended to be a will does not comply with the formality requirements, the Master of the High Court will be compelled to reject the will, in which case the estate will devolve in terms of intestate succession, as I've explained before. So if a will is registered by the master on the basis that it does not comply with all the formalities, any interested party can apply to the High Court for an order directing the master to accept the will. And it's a very expensive exercise to go to the High Court to get a declaratory order for the master to accept that will. However, an application, yes, that's what I was explaining, that an application to the High Court is very expensive and should be avoided at all costs. So when you are considering to have a will in place, you can ask assistance in the drafting of an elementary will from an attorney, chartered accountant, board of executors, even your banks, insurance companies, trust companies, or various individuals who have the necessary background and qualifications to draft wills. The costs involved in drafting wills of an elementary will are usually minimal, and some of the institutions will draft a will free of charge, provided the institution is nominated as executor in the estate. We see it with the banks. If you have, an account with the bank can do that, provided that they be nominated as an executor in the estate. Should a comprehensive estate planning be required, and this includes the drafting of a will, it is recommended that assistance of a professional estate planner be also sought in this regard. Because you know why? Because you might have assets, but if your assets are less than the liabilities that you have, chances are that those assets will be sold to defray the costs so that the creditors can get what is due to them. And then in that event, unfortunately, your heirs will not be able to inherit from the estate. So the professional estate planner will usually charge a fee for his or her services, but the advantages of such services usually justify the costs incurred. If a person has drafted any previous wills or has such documents drafted, it is important to revoke previously drafted wills in a later will. Otherwise, all the wills will be deemed valid if they comply with the formality requirements and will have to be read together. So it's imperative that when you're drafting a will and you want to change it, let's say you want to make a different will altogether, revoke the previous wills, because if you don't, chances are all the wills will be regarded as valid, and the Master of the High Court will read both of them together. Imagine the first will nominates A as beneficiary, the other will B and C, and then there's conflict, the matter might also end up in court. So it's very important that you also keep that into consideration. So who should be the executor? It's a consideration that you have to make. Who can you appoint as an executor in the estate? Do you want to nominate more than one person as executors? Do you want to make provision for a substitute executor? Should the person you nominate not be able to do so, or if they refuse to take up the appointment? Must the executor provide the Master of the High Court with security for proper fulfillment of his or her duties? You must also consider that. So a bond of security will be requested by the Master of the High Court. For example, if you didn't in your will specifically indicate that the executor will not be exempted from furnishing the Master of the High Court with a bond of security. A bond of security, just to be in simple terms to explain it, is like an insurance. So basically the Master of the High Court will consider that the total value of the assets in the estate is this much, and then the master will say, we need a bond of security, that insurance in the total amount of the assets in the estate, for protection measures in a case whereby there is maladministration and there's theft of monies. The master can call up on that insurance and pay the beneficiaries. So the other aspect to consider when you're drafting a will is your marital status. Are you single, married? If you're married, how are you married? Are you married in terms of civil law, in community of property, or out of community of property, with or without the accrual? Is your marriage in terms of customary law or civil union, in terms of same-sex marriages, or is it in terms of a religious marriage, in terms of Muslim or Hindu rites? Are you married in or out of community of property, with or without the accrual? Who do you want to appoint as heirs? The circumstances of your heirs also play a role. As I did say that, when you identify minor children or heirs with special needs, those are the kind of persons that you also want to protect in your will. Are your heirs of minor age? If you are the sole guardian of the minor, you must also make provision that you appoint in your will a tutor or a guardian who will also, take care of the minor. To whom must the minor's inheritance be paid for safekeeping until he or she becomes a major? Options would include the Master's Guardians Fund. As I mentioned, that part of our mandate as of the High Court is to should be made to the natural guardian of the minor, or whether you would create a trust for the minor in your will in order to protect their interest. Do any of your heirs need special protection? You must also make consideration to that. And then heirs who are legally incapable of managing their own affairs, for example, someone who suffers from a severe or profound intellectual disability. Obviously, you will want to protect that person so that no one takes advantage of them. So heirs who cannot work with money, for example, spendthrifts, you still want to you want them to inherit from your estate. So what measures are you putting in place in your will to protect them? What should happen if any of the heirs is insolvent at the time of your death? Because if any of the heirs is insolvent, so the master will actually appoint a trustee if it's a person to oversee their assets, their estate as well. So it has an impact on how the administration of your estate will then be administered. So what type of bequest do you want to make? Is it a legacy? A legacy is, for example, I leave 20,000 rands to my daughter. That's a legacy. It's a cash inheritance, or a usufruct, or I've explained a usufruct, a fideicommusium, or I'm going to create a trust. And then we are going to get to the formalities. Now, all wills must be in writing. So if you make a video of how you want your estate to be administered, unfortunately, if it's not in writing, that will is not valid. So a will can be written by printed the fill-in documents purchased from selective bookstores such as CNA. In terms of the Wills Act, it is possible for a testator or testatrix to sign his or will personally, or to ask somebody else to sign the will on his or her behalf. So it is recommended that if it is at all possible, a testator or testatrix should sign or his or her will personally, because if you ask somebody else to sign your will, and then later there are other aspects, you are no longer there, because you have passed on, it can create a lot of confusion as to what your intentions were exactly. So it's very important that you also keep that in mind. So all wills must be signed by the testator or testatrix at the end thereof. Signed in the case of testator or testatrix means either a full signature, initials, or a mark, or thumbprint, or an X. So basically, when you sign, you can use your full signature, initials, mark by use of a thumbprint, or you can, if you are unable to write, put an X. So a testator or testatrix, if it's all possible, must avoid the using of a mark to sign his or her will, because if they use a mark, then additional formality requirements are set out for the will to be valid must be complied with. The best way to sign a will is to use a full signature. At the end of the will means that the will must be signed as close as possible to the end of the wording of the will, and not the end of the page on which the will ends. So for security purposes, to avoid any persons besides the testator or testatrix from adding information to the will after it has been signed by him or her. So that's why it must be signed at the end thereof. If the will consists of more than one page, the testator or testatrix must sign all the pages of the will, except for the last page of the will, which must be signed at the end thereof. All the other pages can be signed anywhere on the will. In practice, all pages of the will are usually signed at the end of the page. The will must be signed in the presence of at least two competent witnesses who are present at the same time. So when at the signing of the will, the testator or testatrix or both must be there together with two competent witnesses who must be all present at the same time. The competent witnesses are there because they are witnesses, they are witnessing the signing of the will. In case there are any disputes emanating from that will, they'll be able to give evidence in court with regards to the intention of the deceased at the time of the signing of the will. So a competent witness is any person over the age of 14 years of age who is not mentally ill and who at the time at which they witness the will is regarded as competent to give evidence in a court of law. So as evidence of the fact that the testator or testatrix signed the will in their presence, the witness each must sign the will in the presence of the testator or testatrix and each other. Although the testator or testatrix must sign all the pages of the will in the presence of the witnesses only need to sign the last page of the will. And then we continue with the formalities. A competent witness, okay, I've covered that. In practice, the witnesses must usually sign, they usually sign the pages, all the pages of the will. It should be noted that the person who signs the will as a witness need not know what the content of the will is. They must, however, be aware of the fact that they are witnessing a will. A person who, in terms of the will, is to receive any benefit from the estate or his or her spouse should not be a witness to the will, as this will, with certain exceptions, disqualify them from receiving a benefit in terms of the will. So it's very important. A person who is going to witness your will cannot be nominated by you as an heir, because they might be disqualified to inherit. There might be a perception that there might have been an influence, by that person so that they can benefit from your estate. So a benefit in this instance includes the nomination as an heir, executor, trustee, or guardian of any minor children of the deceased in your will. So it is recommended that witnesses be totally impartial persons, e.g., for example, neighbors, friends, etc., people you trust, provided they are not beneficiaries in terms of that will. Where a testator or testatrix signs a will by means of a mark or requests somebody else to sign the will on his or her behalf in his or her presence, then the signing and witnessing of the will must take place before a commissioner of oaths. Examples of commissioner of oaths are police officers, postmasters, bank managers, attorneys, for example. Once the will has been signed and witnessed before the commissioner of oaths, the latter must then add a certificate to the will in which he or she certifies that he or she has satisfied himself or herself as to the identity of the testator or testatrix, and that the document which has been signed and witnessed is in fact the will of that deceased. So basically they have to certify themselves that of the identity of the deceased. The commissioner of oaths must sign the certificate and also every other page of the will anywhere on the page of the will. The certificate by the commissioner of oaths must be added to the will as soon as possible after the will has been signed by the testator or person who signs the will on behalf of the testator and the witness. Otherwise, that will be invalid. A will can be amended by the testator or testatrix at the time of the initial signing thereof, or at any time thereafter. Amendment means any deletion, addition, alteration, or any writing between the lines of the text of the document of the will. Any amendments to a will must be identified by the signature of the testator, testatrix, or the person who signs the amended will on behalf of and in the presence of the testator or testatrix, and at least 2 competent witnesses, all present at the same time. In order to identify the amendments, it must be by means of the signatures that would be made as close as possible to the specific amendments to that particular paragraph in the will. What has been said earlier with regard to witnesses of the will also applies to witnesses to any amendment of the will, which means that you cannot nominate a witness who is also going to inherit from your estate. As with the execution of the will, any amendments where the testator or testatrix signs by means of a mark or requests someone else to sign the amendments on his or her behalf in his or her presence must be made before a commissioner of oaths for that amendment to be valid. The commissioner of oaths must also certify on the will that he or she has satisfied himself or herself as to the identity of the testator and that the amendments have been made by or at the request of the testator. The commissioner of oaths must sign his or her certificate. It should be noted that the witnesses who witness and sign the amendments to a will made by the testator need not be the same witnesses as those who initially witnessed the will. So the same rule applies with regards to the commissioning of oaths by the commissioner of oaths when you are making amendments, if you are signing by means of a mark or by means of a thumbprint. If a will does not comply with all the formalities as mentioned, the document will be rejected by the Master of the High Court. The deceased estate will then have to be distributed in terms of the rules of interstate succession, as I've explained before. It is, however, possible for any person having an interest in the estate to approach the High Court for an order directing the Master of the High Court to accept the document as the valid will of the deceased, even if it does not comply with all the formalities. The court will only grant such order if it is satisfied that the document drafted or signed by the person who has since died was intended to be his or her will. As court applications are costly and also delay the administration of the deceased estate because the master will freeze everything until the court issues a court order, it is suggested that the testator makes sure that their wills comply with all the necessary requirements. Hence, you can ask for expert legal advice when you draft your will. So Section 2B of the Wills Act provides that if any person dies within 3 months after his marriage was dissolved by a divorce or annulment by a competent court, and that person executed a will before the date of such dissolution, that will shall be implemented in the same manner as it would have been implemented if his previous spouse had died before the date of the dissolution concerned, unless it appears from the will that the testator intended to benefit his previous spouse, notwithstanding the dissolution of the marriage. Note that the provision will not apply if it appears from the will that the testator intended to benefit his previous spouse, notwithstanding the dissolution of the marriage. So the intention of the testator is very important to consider. So when you are married and you get divorced, so when you die within the 3 months after the dissolution of the marriage, either by divorce or the annulment, when you die within that period, so the section provides that your estate will be treated as though you were not married. So which means that we will have to take into consideration also whether still would you have intended for your wife or your husband to inherit from your estate? So if after a period of 3 months you didn't change your will after the divorce, and you nominated your spouse, your ex-spouse, to inherit, your ex-spouse will still inherit from that estate. So it's very important to also take that into consideration. Safekeeping of wills. Wills should be kept in a safe place where they can easily be found when the testator or testatrix dies. Wills do not have to be stored at attorney's offices or at trust companies or at the banks. If a testator or testatrix decides to keep his or her will in a safe place, it is advisable that they must inform a reliable person where the will can be found should they pass on. So, communication is very important, so that when you pass on, at least members of your, relatives must know at the point where their will is kept at. When a testator or testatrix dies, his or her estate must be reported with the Master of the High Court, who has jurisdiction within 14 days. So the estate can also be reported at a service point, which we call a magistrate's court, having jurisdiction. If the total value of the estate in the estate is less than 250,000 rands and there is no will. If there's a will, or the total value of the estate, of the assets in the estate is above 250,000, then the estate must be reported with the Office of the Master of the High Court. The estate of a person who died leaving a will, whether it be valid or not valid, must be reported to the Master of the High Court in whose area the person resided before death, residing in. The reason why it's only the master that can decide whether that or not. If it doesn't comply with the formalities of the Wills Act, then the master will reject that will, and it's only the court that will determine the validity thereof. So currently there are 15, just for information purposes, officers in the country, and after the death, the testator, testatrix, or wills, whether they are valid or not, as I explained, and irrespective of the number of the wills, must be lodged with the Master of the High Court for registration and acceptance or rejection. Together with other documents, appoint an executor who must then administer the estate. Any person who steals or willfully destroys document purporting to be will do administration of Estates Act. If found guilty of such an offense, that person is liable to a fine or to imprisonment for a period not exceeding 7 years. So it's very important that you also take that information into consideration. It is also important to note, when you're drafting your wills, go through an estate planning process, during which you actually, make a determination as your estate to pay your debts and administration costs that are, that are going to be paid when your estate is administered. If there's no enough cash in your estate, the executor will have to sell all your assets in order to obtain the cash, or the heirs will need to pay in cash to the estate if they do not want the assets to be sold. Except for the normal debt which need to be paid out of your estate, for example, bond on the house, clothing accounts, doctor's bills, and other outstanding bills, your estate needs to be able to pay the following administration costs as well. So you must bear that in mind, that beside the liabilities, there are administration costs that must be paid. So basically, advertisement costs. When a person dies, the law requires that where letters of executorship has been issued by the master, that estate must be advertised in the local newspaper in the district where the deceased was residing, and also published in the government gazette for debtors and creditors to lodge their claims against the estate. And after 6 months, when the master has issued the letters of executorship, the executor must lodge with the Master High Court what we call a liquidation and distribution account. In short, it's a statement of your assets and liabilities, which must also be advertised in the local government, in the local newspaper, for any person who wants to lodge a claim against the estate, be it's a creditor who has not actually reflected in the L&D account, or an heir who feels that they have a right to inherit. So we're talking about 2 advertisements that must be paid, obviously. You cannot just advertise without paying. So the approximate cost will amount to 500, 600 rands. Executors' fees must also be paid. So executors' fees is determined at 3.5% of the total value of the assets in the estate. And then if the executor is registered for VAT, then the executor is entitled to also charge VAT. Master's fees must be paid up to a maximum of 7,000 rands. General expenses, transfer costs if there's a house involved, bank charges when an estate late bank account was opened, and the bank charges, those must also be paid. Postage and petties in an amount of 260 rands. Clearance costs. Remember, when there's an immovable property, that property cannot be transferred out of the estate until all the municipality costs have been paid in full. Estate duty, if your estate is above 3.5 million rands, 20% of that must be paid to SARS. So that brings to the end. That brings me to the end of my presentation. And I know it's a lot of information, but you know, I think it goes a long way so that you are empowered to know exactly what the strain of estates entails, including the estate planning. Thank you so much for the opportunity. Back to you, Siam.
No. Thank you so much, Penny. I was just on.
Hello.
But yes, Penny, I just wanted to say thank you so much for the presentation. Thank you for your input. We will make the presentation available to everyone. And what we will do, and we will also send it to all our network partners. I just wanted to say, and I just wanted to thank also all our network partners, which is the South African Women in Dialogue. We have the NADAL, the National Association of Democratic Lawyers, Black Lawyers Association. We've got a very young non-profit organization, Sustain Law, which is very passionate Department of Justice, as well as the Law Society of South Africa, for making this available, for ensuring that we can bring this information to communities. What is going to happen now is that we also have a very, our other partner is Legal Aid South Africa, as well as the South African Women Lawyers. And what we will do now, if there's any questions and queries, it will be answered both by Legal Aid South Africa, as well as the Department of Justice. And the Women's Legal Center will also be online. And that will be done now for the next half an hour. And the process is going to be that you can either put it on the chat, you can put it on the Facebook page, or you can decide to also just ask the question. Thank you. I'm going to ask now, Lulama, is there any questions to Penny or to Legal Aid South Africa? One of the questions again has been from Rahima. The presentation will definitely be made available. Hi, Vanessa, you have a question?
Yes, good morning. Can you hear me?
Yes, yes, we can.
Okay, I remembered to unmute. I wanted to ask, one of the rules of having, of declaring an estate is that you have to open a bank account it has to be a check account, and you have to declare that check account to the master. You are only supposed to administer the funds in the estate through one banking account, being a check account, as soon as there is more than R1 available in the estate. Now, what if an executor goes and opens a second account, let's say a savings account, and runs these two accounts together? Do they have to declare both of those accounts, bank accounts, or would it be a crime to not declare the second bank account? That's my question.
Penny, I'm going to hand that question over to you. I don't know if Legal Aid can also answer that question. Thank you, Vanessa. Thank you. I think that there is a problem with Penny's. Penny, can you just unmute? Both accounts. I mean, it's my understanding both accounts have to be, especially if the estate is going to be. Sorry, the estate has to sorry, all information will have to be given to the master. Also, in addition to that, all of that information as assets will have to be placed also on the forms that is provided. Penny will be able to give more information in relation to that, but all assets, whether or not all bank accounts, movable and immovable, will have to be placed on the account. And it is I do believe that if there's a challenge with non-disclosure, the master can pick that up. Lulama, is there any other questions? What happens if a person dies without a will, but also co-owns property with siblings? And then there is another question. Can you give some examples of the mistakes women make when it comes to estate planning and making wills? Can I hand that over to Legal Aid South Africa?
Good afternoon, everyone. I'm connecting from my phone. I'm trying to check those questions. Okay. The first question was, what happens if a person dies without a will, but also co-owns a property with their siblings? So when a person dies without a will, the assets then will be administered in terms of the Intestate Succession Act. And then when you co-own property, you normally own shares in that particular property. So your shares in that particular property will be dealt with in terms of the Intestate Succession Act. The presenter have explained what happened. And then the next question, can you give some examples of mistakes women make when it comes to estate planning and making wills? The common mistake that most people make, especially when they have dependents, sometimes as parents, they want to disinherit some of their dependents. And when they do that, they are now opening a gap for that dependent to come back and then lodge a claim for maintenance if that person is still dependent on you. So those are some of the common mistakes that people make. And then the other one that people make is after your marriage is dissolved, either by divorce or annulment, some people forget to go back and change their will. And after a period of 3 months, then we assume that you actually intended or you actually wanted your former spouse to inherit from your estate. So people sometimes they forget to go back and interrogate their wills and change them. I have also seen another question. I don't know if I can go to it from Makwela Albert, which asks, can the will be declared invalid after the testator has passed on? The answer is yes. If those who are left behind have reason to believe that maybe that will, at the time the testator attested to it, it was made under duress, or that testator was not in a proper state of mind to can draw up a will, they can still challenge it. Wills can still be challenged after the testator's death, and that's very common. Because normally when the testator is still alive, we don't even know the will exists. Some of them keep it very, very private.
In addition to that, is there any examples that we can also place before in relation to what advice can be given to women or partners who are left with nothing to their names whilst the estate is being finalized? And then there's also an additional question, is there a way of getting out of the community of property, especially if one partner does not contribute fairly and the other one is financially overburdened?
Okay, to answer the latest question, is there a way of getting out of the control property, especially if the other partner is not contributing? Yes, but it's quite a process. You have to apply to the High Court for the change of your marital regime. So what you have to do is a long process, because you also have to notify all your creditors that you intend to change your marital regime, because remember, now your estate has to come together and be divided. So the other way, which is actually a shortcut to it, is to get divorced and remarry if you want to do it. Either way, you have to still deal with your debts. Either way, you still have to deal with the division of your joint estate. So you can change your marital regime from in community to out of communal property. And the other question I wanted to answer was, okay, what advice can women be given, women or partners who are left with nothing to their name once the estate is being finalized? Remember, it depends on your marital regime. If your marriage is income to property, you're automatically entitled to 50% of the whole joint estate. So before, for example, let's say your partner or your spouse has a will, and then in his will has bequeathed his entire estate to his son or to his mother or the son, whoever he chose to bequeath it to. What we have to do is remember, when he do that, he's only bequeathing 50% of the joint estate if you're married income to property. So your share of the estate still remains, you're still entitled to it. So if that is happening and then they're trying to finalize and not get to anything in terms of the will, that's the time that you have to.
Phone quickly, Shima. Oh, okay. Oh, sorry. Sorry. Thank you very much for that. Lulama, can you just read out all the other questions and just take it further? Thank you.
Miss Ya.
Thank you very much. I mean, there isn't a lot of other questions that have come forward, and I have requested that the question be fielded. Lulama, can you just do that? Is there additional questions? If someone is nominated as an executor, can they resign? And are the legal and financial implications of resigning? What is the legal and financial implications of resigning? That is another question.
Can I take that? Can I answer that question, Shyam? Hello, can you hear me?
Yes, we can hear you.
You can hear me? Okay. Sorry about that. My battery got, it's flat, so I couldn't connect, but I have reconnected now. And the question with regards to whether there are any legal, penalties if a person resigns as an executor, there are none. Because remember, you are nominated and it's up to you whether you accept the nomination, and however, if the letters of executorship was already issued by the master, and you also drafted the L&D account and lodged it with the master, so you can resign at any time. The law also, the law actually gives you the right to also resign in terms of Section 54 of the Administration of Estates Act. But however, you'll still be accountable up to the time before you resigned. Thank you.
Okay, afternoon everybody. That is it for today's slot of World's Week, and this is part 1 of 4. Thank you everybody, and we'd like to also extend our thanks to the Department of Justice and Legal Aid South Africa for presenting and helping us prepare for the workshop. Thank you very much.
Thank you.